So to make a start, I would like to ask Sal as a kickoff. So have you seen this shift more towards remote working in the UAE? And what are your thoughts on this, please?
Sure, yeah. Hi, everyone. So personally, what I have seen over the past year is employees actually having to leave the UAE, particularly to just go and look after their loved ones. So where remote working was not really seen or fond of for various reasons. But I think as times have moved on and we're kind of heading towards sort of Q3 2020 and going into Q4, a lot of companies were struggling to find ways to kind of motivate and incentivize employees given the pandemic. And further, towards the end of every year, there's always one thing HR and sort of leaders always look at, which is funds for salary increases and bonus awards. And this was a big sort of confrontation with most organizations because there wasn't the fund there. So one of the questions that I was asked on a regular basis was, how can we continue motivating and incentivizing our employees as an added benefit? And one of the things that I did with sort of my teams remotely was look at, as a town hall meeting, what could we do? And what we came up with was actually the remote working seemed to really benefit a lot of employees, and not just only with our organization, but organizations globally. So, and the freedom to be able to live anywhere in the world is so important, particularly for the younger generation and expat employees who want to be able to work overseas, but also be able to have that flexibility of going back and forth and seeing their families. And obviously with the UAE, you also get to enjoy the sort of warmer climate and the scenic views, and also the recreational sort of facilities are on hand in the UAE. So I can definitely see why we should be prepared to see more employees banging on employers' doors with requests to sort of work remotely or abroad. And actually, I think the crisis has actually opened senior leaders' minds in adapting to a working sort of culture from anywhere. And it's something that as HR professionals, we are been looking at strategies and policies to be able to put into the workplace. And it will be a factor to think about in terms of actually attracting global talent. But yes, as HR practitioners, Emma, and we know that there's some really important legal issues to consider when helping the business develop a strategy around this.
Okay, thank you, Sal. That's really good initial insight. So we're going to have about 4 which allows for perhaps not in depth, but we want to be able to cover a lot of ground. The topics that we will be immigration, local employment rights, documenting the move, confidentiality, insurance, health and safety, tax and social security, and regulation restrictions. Going logically through these areas one and focusing in. So I think we're going to have a Q&A session of which will be kicked off by Sal.
Sure. So question to you, first of all, Emily, around immigration. Fundamentally, employees can work in any location where they have the legal permission to be, and of course, the right to work. Emily?
Unmute, Emily.
Unmute. Typical. Someone had to do it, so I'm going to be the first and hopefully the last. So I'll start again. Thanks, Al. You're absolutely right. Unless an employee is a citizen of the country they want to go and work from, it's going to be essential to make sure they've got the correct permission to work there. And they certainly shouldn't be undertaking any work without having the right visa that allows them to work, even if it's for a limited period of time. If you've got an employee who ends up breaching local immigration laws, then not only is it going to have serious consequences for them, but in terms of the reputational damage on the employer or consequences if it gets out that you have people who are out in the world not abiding by local laws, and obviously the individual should be concerned about fines for themselves and potential travel bans. So definitely, one of the first pieces of the puzzle is getting to grips with the local advice on the immigration requirements locally, wherever it is they want to go and work from.
Okay, that's great. And how exactly does the remote working visa work in Dubai then?
Right, so I mean, it's all very new, but fundamentally, the new visa, I say new, it was launched in October 2020, and officially it's called the Dubai Virtual Working Programme. And essentially it's for individuals who want to come and work in Dubai for up to 1 year to perform their existing role or job for an overseas or foreign employer.
Okay. And who is eligible for the visa? Is it open to anyone?
Well, it's open to existing employees. So anyone who already has a job, so they need to be employed under an employment contract, earning a monthly salary of at least the equivalent to 5,000 US dollars. And that employment contract needs to be lasting for at least 12 months. Having said that, it's also open to people who own their own business, so entrepreneurs, as the rules refer to them.
So is this on the premise that the working in Dubai is a temporary move, i.e. people can come to Dubai, work remotely, but show an intention to go back to their home country and work for their employer after the 12-month period?
Yeah, I suppose so to a degree, but actually there's nothing stopping employees from applying to renew the visa. So yes, you can apply for your 1 year, but as things currently stand, so long as that employee continues to be employed by that employer at the end of that 1 year, and they want to stay and the employer's happy for them to stay, then so long as they provide the necessary documentary evidence of that ongoing and continued employment, then that's fine. So it's the same contract of employment perhaps that you would submit at the beginning of the application process for the first visa, and they would just apply with the same documentation. As to business owners, entrepreneurs, they need to provide proof of ownership of the company. And again, there's a 12-month requirement. So they need to show they've owned the company for at least 12 months. Again, as things currently stand, you talk about owners of a business, but actually there's nothing in the guidance that the company needs to be 100% wholly owned. So it doesn't need to be, the sole shareholder.
Mm-hmm.
It doesn't even say, you need to be a majority shareholder, or that there is a minimum, de minimis shareholding requirement. So in theory, you could hold a small number of shares and apply on the basis of being a company owner.
Okay. It seems to be limiting to kind of senior employees, like salary of 5,000 US dollars is quite high, don't you? Or would you think that will be reduced at any stage?
I agree, and I think potentially yes, it is limiting. However, on a positive note, I understand the current minimum salary requirement is being reviewed, and certainly the expectation is that it will be reduced, which should actually make the program much more accessible.
Oh, that's welcoming news, especially if it makes the process more open and simpler. Although generally in terms of the application requirements, the process as a whole is relatively simple, isn't it? Which is quite welcoming in itself.
It is, and before I came to Dubai, I used to work in the UK, and I did a lot of immigration work. So comparatively, this visa application is very, very simple, even to other applications in Dubai or the UAE. So apart from the employment contract or the proof of company ownership, if you're an entrepreneur, the only other documents you need to provide are your proof of income, so latest payslip and some bank statements from the last 3 months, the passport, and that needs to have at least 6 months validity left on it, a valid health insurance policy, and your passport photo, and that's it. So it's a relatively short list. Of course, the documents need to be translated into English or Arabic and also attested. So that adds a bit of time and process, which you'd want to build in as part of the whole application. But apart from that, there's no long or detailed application form. It's just those documents you send in.
Okay, and that's all done by email? And how long does it take for a reply?
Yeah, all by email, and it can be done before the employee gets to Dubai even. So if they do that, they will get issued with an entry permit. So that's to get them into the country, and that's valid for 60 days from issuance. And then when they arrive, arrangements are then made to get their medical done and apply for an Emirates ID card. Alternatively, if they want to enter Dubai first, they can do that on a tourist visa, submit the application in country, and if it's approved, then just their visa will be switched over to the remote working visa. And as you'd expect, there is a slight difference between in-country and out-of-country applications in terms of the price, so that's one to check. As to timing, once they've applied, you should expect a decision within a month or so.
Okay. And how would you describe the legal status of the employee? So when they're in Dubai, what exactly are they allowed to do? Because they get the Emirates ID and the medical test, just like all the other residents. So what other residency rights do they get? And are they actually, more importantly, backed by the UAE labour law rights?
It's a good question. In short, the answer is no, or not really, because the fundamental principle is that the employee isn't meant to be working for a local employer. They're not here being sponsored by a local entity. Of course, as you said, they do get all other residency rights, so they can open a bank account, you can sign a lease on an apartment, but it doesn't provide the means to get a work permit, which of course is the prerequisite to work lawfully in the UAE. And that's, I suppose that's intentional, because the idea is the employee should be remaining subject to the location or jurisdiction where the employing entity is based. Now, of course, being lawyers, you can see the lines getting blurred where perhaps, you know, the employer happens to have a local branch or subsidiary in Dubai, and the employee's duties have some connection to the activities of that local entity. And perhaps the employee uses that connection to try and file a claim. I'd say that's probably unlikely, because if an employee brings a claim in that kind of circumstance, then it's going to expose themselves to the risk of sanction for working illegally, as well as the company, the local entity. So yeah, I think it's probably unlikely that they would do. And in any case, without a work permit, for those, certainly for those cases where the federal labour law is enforced, or the areas of the UAE where that, or Dubai where that's enforced, can't imagine a claim would be allowed to proceed. We can't imagine that the ministry would entertain a request to get approval to proceed to the courts without having that work permit. And I suppose the same applies elsewhere. So I suppose DIFC, the Dubai International Financial Centre, which has its own common law system and its own employment law. And I don't think I would totally rule out the possibility of the DIFC courts possibly entertaining a claim. Certainly if an employee could show a sufficient nexus between the work they've been doing here in Dubai, the local DIFC entity, and applicable, you know, DIFC employment law, other employment-related regulations, then I can see that might possibly fly, even without there being a local formal employment visa underpinning the work that's been done.
Right, that's really interesting, because it's not always the case that employees working in other countries don't become subject to local laws.
Indeed. So it's certainly something to check. I think employers really need to be aware of applicable local employment laws if you're going to be allowing or making arrangements for employees to work overseas, especially if it's going to be for an extended period. I mean, I'll let Kirsten talk a bit more about that, but before we move on to local rights, I'd just make a couple of final notes on the kind of immigration piece. One that, you know, employers, we're talking here about the application, this is the upfront visa application, but also think about what happens at the end of the arrangement. So whether there may be an issue that when the employee returns home, there is some bar on them either returning home or even being able to work. Because in certain jurisdictions, if you're absent from the country over a certain period of days or months, it could invalidate that employee's residency visa there. So you want to try and avoid a delay in their return or other issues with them being able to work when they get back, assuming they decide to go back. And you know, that also applies in terms of their longer term or permanent residency rights, if that's something the employee might be looking to apply for in the future. So best to check that before getting stung on the return.
Brilliant. Thanks, Emily.
Okay, I'll jump in here and I'll direct a question related to local employment rights and obligations to Kirsten, if that's okay. So Kirsten, where would I start in terms of finding out what type of laws, obligations that might come into play? And particular obligations that need to be on the lookout for?
Yeah, it's a good question to start with, Emma. Now, I mean, a lot of businesses will already have very mobile workforces and will probably be quite used to some of the complexities and the implications of sending employees abroad, for example, on international holidays. But for many, this is probably the first foray into the world of the anyway, if you're very experienced at this or completely new, not just on the employment implications, not just but also and something you have to tax come on to later. Now, this is probably the sort of exercise that Emily and I are involved in called across a number of jurisdictions. It some things to be on the lookout for. First, whether there are any mandatory provisions, regardless of what the contract says, something if there are, the provisions apply. Now, a lot of statutory employment rights have a minimum service requirement before they kick in, but many others, for example, discrimination rights in a lot of jurisdictions apply from day one. And finally, advice should always be taken on where those rights could be enforced later on, for example, in the local courts or in the courts of the home jurisdiction, or potentially in both.
Okay, so it sounds as though employees working remotely from abroad could end up with a greater set of employment rights than their peers who are still working for the same company back in their home country.
Well, yes, that's absolutely right. Each case will necessarily be very fact specific, but depending on what the employee is doing, where they're doing it from, and how long they're doing it for, it is perfectly possible that they could end up with two sets of employment rights, and worse still for employers, have the option of more than one jurisdiction in which to try and enforce them.
So from a HR sort of practical point of view, that to me sounds quite admin heavy. Is that how you would perceive it too?
It certainly will create some admin challenges, not only in terms of making sure that all the applicable statutory rights are being met, but also that they're being documented appropriately and that all of this is being done in accordance with local law requirements. It could also, looking at it from a more practical point of view, create some inequality between employees in terms of the rights they have. I mean, you could end up almost with a two-tier workforce in terms of things like annual pay and leave, or minimum wage, or family-related leave, and even on termination rights. Now, we all know that terminations can be tricky at the best of times, but they will be even more so if you're trying to make sure you've complied with the laws of more than one jurisdiction at the same time. And if things do turn contentious, you can easily find yourself facing either concurrent or successive litigation on multiple continents. Just to give a sort of real life example on that, we actually had a client who terminated some employees perfectly lawfully under the laws of the UAE in accordance with local law, only to then find themselves facing claims brought by those very same employees back in their home country of the Philippines, which then succeeded because a few of the mandatory steps required under local law had been missed.
Okay, so just to delve into that, some contentious situation. So for HR and people that are managing businesses, this could relate to perhaps performance disciplinaries. So how do you manage that bit remotely? That's a little bit conflicting in some of the marketing that's been done program. Do you want to mix business with pleasure in Dubai? It says that the idea that you can live and work somewhere that's also very fun. What if there's a doubt then in the minds of employers that perhaps there's too much pleasure in terms of managing that from a legal perspective? Potentially see that as a bit of an issue.
Yeah, no, absolutely. It's a really good point. And in fact, it's topical as well. And we covered managing performance and disciplinary management on a remote basis in a recent client briefing. And if anybody who's attending today does want a copy of that, then do feel free to get in touch with us after the webinar.
Specifically, what kind of performance or disciplinary issues have you seen? Do you have examples of things that have been flagged up?
Yes, I'd say, I mean, as always, there's a myriad of potential issues, all of which arise in normal working circumstances. So regardless of whether there's an overseas element, but which are definitely going to be exacerbated if you have got staff who are working remotely or overseas, largely because of the lack of physical or local oversight. So some of the prime examples I'd give would be being uncontactable, especially when they're working in a different time zone. They might fail to attend online meetings, or perhaps start taking a disproportionately long amount of time to respond to emails or calls. They may not be engaging in their tasks properly. They might make false claims about the number of hours that they've worked. We've seen that. And then at the sort of perhaps more catastrophic end of the scale, they could be breaching confidentiality or perhaps even making preparations to compete.
Okay, so if or the respective HR person that's responsible for managing this, how would you recommend or disciplinary related processes from a remote location?
Yep. I mean, I would start from the basis that all of the usual best practice guidance that applies to any fair performance or disciplinary process in any jurisdiction will continue to apply when you're trying to do this in a remote or overseas working context. So, for example, employees should be told about the nature of the issues to be discussed. They should be given copies of any evidence, and all of that should be done a reasonable amount of time in advance of any meeting. Internal investigations, I would say they should still be pursued with the same vigour as they would be when everyone's in the office, but extra care will need to be taken to make sure that you're not in danger of breaching any local laws. So, for example, any local data protection or cybercrimes laws that might have an impact on your ability to either monitor behaviour or to gather evidence. And if it gets to that point, there's no reason why a virtual performance improvement plan can't be put in place. It should still be prepared and implemented just as you would for an employee who's working from the home office. So include targets and timescales, again, subject to any local adaptations that might be needed. I think, one of the biggest practical challenges is going to be getting the meeting logistics and the meeting protocols right. You're going to have to hold it remotely, unless by chance somebody happens to be in the country that can represent the company. Phone is less ideal than video call because it's harder to get a sense of people's responses if you can't see them. And thought will need to be given to things like timing, to take account of time zones or perhaps childcare commitments, and to whether the employee will be allowed to record the meeting. And if you'd rather they didn't, how on earth are you actually going to prevent that from happening remotely?
Okay, all of that is very clear. I do see that there are some pitfalls associated with trying to do this from a practical point of view. In terms of HR colleagues supporting sort of process remotely, it would be useful, I guess, to have guidelines or kind of policy in place. So everybody knows what's expected and how this process should be managed.
You're absolutely right, Emma. And any existing policies already in place should be updated to include the practicalities of monitoring work output and monitoring employee conduct when they're working remotely overseas, and also the process, as we've just chatted through, for dealing with any issues as and when they arise.
Okay, thank you. I've put my headphones. A bit of, I know there was some interference. Hopefully this will help that. Just moving on to the next. Documenting the move. To you, Emily, if an employee is going overseas, then there's likely to be some extra paperwork and that needs to be done. Going back to look at whether your organization should have a specific form, perhaps for employees to make their request to work overseas. What are your thoughts around this?
Never learn. Thank you for that. Yeah, absolutely. Definitely employers need to think about, the whole process of remote working and getting that documented. So everybody's clear what their expectations are of each other.
Yeah.
In terms of the form itself, or the request form to work overseas, I think from a legal perspective, it's not something I think would be mandatory, but in terms of record keeping, it would be helpful for audit purposes to have a trail of how the arrangement came to be, or how it developed. So it's really a matter for each business to decide what to put in there.
Yeah, I would go to have something. I think certain business areas it would be worth requiring employees to accompany the request, perhaps with a case for why they're requesting that. What?
Yeah, absolutely. I think that's a good idea. I'm actually currently advising a company, a foreign company that has an employee who wants to work in Dubai. And in their UK role at the moment, they've got a number of Dubai-based clients. So as part of his business case, it's exposing the possibility of expanding the business. So, allowing him to perform his role in Dubai would allow the company to kind of softly assess the scope for expanding the business to Dubai and establishing a more permanent presence. So that's one way in which the whole business plan or business case could work. Businesses could even, model the structure of the request form on something similar that you have back in the UK, where I used to work, where you have a flexible working request regime for employees who want to formally request a flexible working pattern. And part of that, they're asked to identify what the impact of what they're asking for would be on the business, and how any negative effects they identify could be mitigated. So, you could do the same with the request for overseas working. If an employer wants to go and work from somewhere in the world that's got unreliable electricity supply, or the internet connection is unstable, or they may be in a completely different time zone. I think Kirsten mentioned that in terms of performance reviews. Then the request form could be prompting the employee to have thought about how the business could minimise the effects or the impact of those things on that employee's ability to continue to contribute and be a productive employee, even from abroad.
Okay. Another question really on the time zone aspect. So to change the hours in the employee's employment contract to then reflect the actual hours that they would be working at the base of the company.
Yeah, potentially. Again, I think it depends on the nature of the work and the business. And of course, any local law restrictions on working hours. So going back to getting to grips with the local legal limits. I think it's actually crucial to establish the boundaries of working time, and in particular, when those employees who might be working remotely from abroad will be available to you in the business. Is it going to be a flexible arrangement, or does your business require them to observe their existing working hours from the home location, no matter what time zone they're in? Or can you agree something in the middle? Can they be available at a core set of hours that overlaps perhaps with the normal business hours of their home location?
Okay, so seems like it's sort of an agreement then between the business and to see what's going to work best for that business. Yeah. So in relation to other contractual, need to think about the term employment remote working. Permission is granted, I assume. Is there a general list of the terms and conditions that would need to be amended?
Yes, probably. I mean, generally before doing that, the stock advice is that employers need to think about whether they actually have the contractual right to make changes. Of course, in this scenario, if it's the employee instigating the move, then getting their express agreement to changes to their terms and conditions to work abroad shouldn't really be an issue. Okay. But yeah, I think as a minimum, employers should be thinking, first of all, place of work. That's an obvious term to change. Think about reserving the right to change this for business need. So you might be happy right now for the employee to go and work abroad, but you would want something in, whether it's the contract, side letter, whatever agreement should provide you as the employer with as much flexibility as possible to terminate that arrangement and require the employee to return to work from the original country of work as needed. It may be actually that if the company's got an overseas office in that location, subject of course to any legal risks, so immigration, tax, so on, employers may well want to require the individual to spend some time in that office from time to time. So perhaps for external meetings or training, or even to do the appraisals or the performance reviews. And that could be in the contract. We're talking about another country, so you also want to be thinking about dealing with the applicable law provisions in the contract. Do we need to change this, update this, thinking about how the local law operates and will impact the arrangement you have in place. It's really important to understand whether that employee is going to be able to rely on local laws, and how they may enforce or look to enforce them, as we've already discussed. And whereabouts in the world could you be getting employment claims from your employees? There's going to be some costs involved, so I think you'd want to be looking at the expenses clauses in the contract, or your expenses provisions in your in a dedicated policy, or if it's a specific document for this arrangement. Are you going to be covering all of the direct costs? It'd certainly be wise to update any provisions you have on expenses to be clear about what overseas expenses the employee can claim back. For example, we could be talking about a new internet connection, mobile telephone charges overseas, possibly even increased or locally required insurance premiums. I think it's probably something that isn't really thought about upfront, but as much as you can try to quantify or think about the costs that might arise and try to bottom that out. I mentioned, for example, one of the requirements for the Dubai visa, the remote working visa, is that the employee has health insurance with UAE coverage. So that, who's going to pay for that insurance? You guys have touched on performance. So you may want to update your provisions on disciplinary matters, or what matters will lead to a disciplinary process. Going back to what you said, Emma, about the pull of the beach, you could be looking to amend those provisions to be clear that employees shouldn't be using work time abroad to top up their tan, and be specific about where they actually do their work, and breach of those terms will then lead to disciplinary or possibly dismissal. Confidentiality is another term we would want to perhaps update or include, if you haven't got express provisions already, to have some clear confidentiality obligations in the contract that make sure employees are aware of their duty to keep confidential information secure, which may be more difficult overseas, depending on the infrastructure. And again, going back to the local law, you may well, for example, for an employee who wants to come and work in the UAE, you might want to be flagging in that contract or the arrangements that, disclosing company secrets in the UAE is not just a civil matter, it's actually a criminal offence under the UAE penal code. So something you may want to underline in the documentation. And then I'd say more generally, you'd want some indemnities. So this is really a set of obligations on the employee to make good any loss or liability that the employer incurs. So I think they're probably the top new or amendments you'd be making. But you also want to be thinking about any particular policies you already have that you just want to reaffirm and remind employees that, just because you're in another country doesn't mean they don't apply to you. Typically that would be confidentiality, for example. Codes of conduct may be another example. You may well even, actually that may be something you probably would look at adapting or updating to say, we need to take account of local attitudes, traditions, if the employee is going to be expected to dress or behave appropriately and respect local decency and dress codes, and that may be something you highlight in documenting this arrangement.
I'm on mute. Thank you, Emily, for that. That's a lot of insight into that. Sal's going to take over the next area.
Sure, thanks, Emma. So confidentiality, data protection and cybersecurity, Kirsten, obviously a very important topic, and confidentiality seems to be an issue that's likely to be a really difficult one for employers with employees, especially when they're working remotely. Any sort of thoughts on this?
Yeah, I mean, I don't think you can put it high enough in terms of potential risk exposure area for employers. Protecting confidential information is a challenge at the best of times. And from my perspective, it's been made even more difficult during the pandemic, because literally overnight, we had this explosion of remote working. And the biggest challenge, as has been sort of pointed out previously on the webinar, is this lack of physical visibility that employers have when staff are working remotely. A lot of the pre-pandemic measures that all the good and prudent employers already had in place usually relied quite heavily on the ability to physically monitor and physically control behaviours in the workplace. So, for example, some of the most common early warning indicators that an employee might be up to no good include staying late in the office, or coming in at weekends when there's fewer people around, or increased use of photocopiers and printers. I mean, in a digital age, that sounds a bit old school, but these are often key indicators that something's afoot. But of course, those indicators are either impossible or much harder to police when the office, and now even the home country, is no longer the usual place of work. It's also, I think, when you're dealing with employees working overseas in particular, much more difficult to restrict and then police how and by who any of your confidential information is being accessed. And I think what really caught a lot of employers out is the speed with which we went into lockdown pretty much across the globe. And a lot of employers didn't have the time or the resources to make sure that staff were kitted out properly to enable them to work from home. And that meant that a lot of clients that we've been helping have had to relax any sort of pre-existing bans they had on using personal devices, or even from taking confidential information off site. And we've already seen a number of our clients experiencing their first taste of employee competition and data theft as an absolute direct result of having to relax their usual procedures.
Okay. Are there any practical considerations around this?
Yes, lots. I mean, apart from obviously the most important start point, including those express confidentiality terms that Emily was just talking about in the documentation, some of the more practical measures that you can take are things like using passwords or ethical walls to restrict access to confidential information in the first place. If you've got employees who are going to be working from shared accommodation, or perhaps overseas from hotel accommodation even, you're going to want to try and reduce the risk of who can, whether accidentally or intentionally, take a sneaky peek at confidential information. So the use of privacy screens on devices can be helpful, or making sure that they have to make work-related calls from a private space rather than the hotel bar or poolside. You're also going to want to ensure that any security updates, or if things really go wrong, remote deletion software can be rolled out, irrespective of where they are in the world. And ideally, although these days it's a bit more impractical, only let employees use employer-provided computers or phones, because it's much easier for you to monitor their activity on those, for example, through document history reports or call logs. Now, again, this sort of chimes in with something Emily just said. You have got to be very careful that any sort of monitoring system you are trying to install can lawfully be installed, because inevitably there will be some local law considerations on that. So, as Emily flagged, in the UAE, your ability to monitor what somebody's doing on a computer system needs to be compliant with the local cybercrimes law and the local data privacy laws. If you have to let people use remote devices, you can also try and put a ban on them downloading or saving any confidential information to that device. And I say especially if it's linked to an automatic cloud-based backup system, that's going to be completely outside of your control otherwise. And also impose a requirement to use only secure Wi-Fi networks or employer-approved video conferencing facilities.
Okay. So on data privacy and data protection, it's possible that the employer regularly transfers personal data to employees in the course of work. Are there any special considerations in the context of employees working remotely from abroad?
Yes, absolutely. Employers should always ensure that they've got appropriate safeguards in place for monitoring and protecting the transfer of data. And these days, and in the context of today's discussion, those protections need to be in place not only within the organisation, but also outside of the home country where the employee is usually based. So particularly if you've got an employee whose role involves actually controlling or processing personal data, or even you just need to transfer their personal data across borders. Some of the key questions to ask yourself would be whether your existing data protection policies cover international data transfers in the first place, and whether they cover them to that particular country. Another key question will be whether data is being transferred to a country that is recognised as having an adequate data protection or privacy regime in place. And if the answer to either of those questions is no, you're going to have to think about what measures or what additional contract terms that you need to put in place to cover this. I'd say nowadays, most of the countries that we're all dealing with have quite well developed data protection and privacy regimes. And there's often mutual recognition of those regimes and the adequacy of them as between certain countries. But just a health warning here, that's definitely not always the case. And just to give a very localized example, whilst we have the DIFC free zone here and also the Abu Dhabi equivalent, the ADGM, who both have specific data protection laws in place, meaning that transfers of data between somewhere like the DIFC and the UK should be reasonably safeguarded, the rest of the UAE has no such regime. And even transfers from the DIFC to the UAE are not recognised as transfers to an adequate jurisdiction.
Okay, so what about the risks of data being intercepted by cyber criminals, or worse still, employees being duped by cyber attacks?
Yeah, that's an excellent and super topical question. And sadly, certainly what we've seen since the pandemic hit is that there's been a real rise in the number of cyber attacks. Hackers have been trying to exploit changes in working habits and potential loopholes in systems that frankly just weren't set up to deal with this level of global mobility. There's actually a really interesting report that IBM produces annually, and which looks at the costs of data breaches on a global basis. And they survey around about 17 countries and regions, including the Middle East. And their findings this year, or for 2020, were that the average cost of a single data breach was about $4 million. Now that's a pretty significant sum of money for most businesses. Worse still, the average time to even spot and then contain a breach was about 280 days, rising to 315 days, so almost a year to spot and contain a breach where that attack has been caused by a malicious cyber attack. And over 3/4 of the people that were surveyed thought that those problems had been exacerbated because of the increase in remote working. So with those rather depressing statistics in mind, every prudent employer is going to want to take steps to identify how at risk they are of a data security breach and what their business continuity or other response plan is going to be in the event that something goes wrong. It's very, very worthwhile introducing cyber risk training for employees, just generally, but certainly ahead of any move overseas. They need to be educated on their obligations in relation to data protection, what is and what isn't authorised, and what cyber risks they face, and critically, what they need to do when things go wrong. Now, in some jurisdictions, for example, the DIFC, the requirement to carry out data risk assessments is actually built into the legal framework, in that case, in the DIFC data protection law. And a number of regulators over here, since the pandemic hit, have been issuing guidance and recommendations for the firms that they regulate to roll out specific cybersecurity awareness campaigns, to ensure that business continuity and disaster recovery plans specifically cover any unexpected disruptions, or how they're going to manage business critical functions when staff are either working remotely or overseas. The DFSA was one such regulator that issued guidance on that, and the Abu Dhabi Global Markets equivalent, the Financial Services Regulatory Authority, they both went on the offensive with those. So again, going back to the documentation, these are all issues that should be addressed within a proper and appropriately worded IT and telecommunications policy, and one that has been adapted, if it needs to be, to deal specifically with remote overseas working. And again, all the protections we talked about in relation to confidential information, think about those practical steps as well. So think about insisting on only secure Wi-Fi connections being used, and to the extent possible, only employer provided kit being used as well.
Thanks for that. Just you mentioned something on training there. If anyone listening in on the call wanted cybersecurity training, or even for myself, I wanted to implement it in my organization, could I do that through your firm, or is that arranged separately?
Yes, there will be aspects of it that law firms would provide. I think, you know, there'll be on the legalities of it. But I think if you're looking at sort of more technical options, which I think you would need to couple with that as well, you would want to be dealing with some of the IT forensic experts, of which there are some really outstanding ones in the region. Again, ones that we would recommend and work closely with. So if anyone is interested in that sort of training, then yeah, feel free to drop us a line.
Thank you.
That big chunk of what you've just spent in, it just makes you realise that there would be some help that bit, because it's business critical, and the damage that could be done if it wasn't as it needs to be. Another area which you're going to touch on is safety, an important topic everywhere for everyone. So Emily, how do this is impacted in relation to remote?
Well, employers around the world will often be under a duty to protect the health and safety and the welfare of their employees. And I suppose it's thinking that could actually include where they're working from abroad under arrangements that have been agreed with the employer.
Yeah, so further away you are, harder this will be managed. So from an employer perspective, is there anything that they could be doing to make sure that they're complying to and safety rules, regulations?
Yeah, I think the first step is ascertaining any local health and safety requirements. So always going back to the local law perspective. So just checking if there's anything that might apply specifically in the country the employee is going to be working from. You know, in some jurisdictions, it might be essential that employees have certain equipment that they need to ensure a safe working environment, even from home. And in terms of the distance or remoteness of managing that, as an employer, you could facilitate or help employees to carry out self-assessments, or depending on what they do, or their original setup, you might want to look into arranging external occupational health assessments at the company's expense.
Okay, and just referring back to earlier where you went into some detail about documenting and policies, how this area, is there anything that needs to go contract or policy in relation to health and safety?
Yes, I think where it's relevant, you'd want a contractual requirement that employees carry out the self-assessments I've just mentioned as and when directed. You'd also probably want a requirement that employees comply with public health guidance applicable in the country they're going to be working from. So, you know, that at the moment, that's likely to include things like quarantine periods or travel, whether that's internal or external. You could also have a provision about financial assistance. So we talked about getting specialist or any necessary equipment. And I know a lot of employers, certainly over the pandemic, have been making financial contributions towards the equipment for home working. So if that's something you're going to be happy to apply abroad, then you'll probably want to think about the amount and whether that should be the same as the general policy, given exchange rates, but also bearing in mind the different purchasing power abroad, so whether the employee can get more or less with that same grant.
Okay, so you've suggested the onus, if you like, of the self-assessments is to go on the employee, given that it's very difficult to assess the health and safety risk from abroad. Does that mean that the employer is taken off the hook for any health and safety issues that arise during that period?
Well, employers are never fully off the hook. I think certainly employers should do as much as you can to put some onus on the employee, because they're in the location, and in most scenarios only they can physically see the risks. But employers should still try to conduct health and safety risk assessments in relation to all of their employees' remote workspaces wherever they are in the world. And that can be done by getting as much information from the employee about where they're going to be and what their setup is going to be. Appreciate that's not always going to be easy to predict up front, but it's a continual process. So as an employer, you want to be trying to give as much thought as possible to seeing if you can identify any location-specific risks or hazards. And that should be periodically reviewed. And in some circumstances, it may well involve the engagement of a local health and safety or risk consultant.
Okay. Earlier, you'd mentioned the health insurance aspect, obviously, as it being a prerequisite for people living in Dubai. Are there any other types of insurance that need to be taken out?
Yeah, I think if an employer is going to be providing equipment, then certainly that needs to be covered by the company's insurance policy. So for example, if you've got an employee who's already working on a company laptop and they're going to be using that to work from abroad, then as an employer, you'd want to be checking whether any cover will need to be obtained or extended if you already have a policy in place. Alternatively, you may well put that on the employee. So you may require the employee to take out and maintain satisfactory insurance. And if that involves any additional costs over and beyond a standard insurance policy, then you consider whether you're going to reimburse the costs involved with that.
Okay, thanks, Emily.
Sure.
I think Sal is now move on to tax and
social security. Yeah, thanks, Emma. That's all really helpful, actually, Emily and Emma. Thank you. I've just got some questions around the financial considerations of employees actually wanting to work abroad. So as a HR practitioner, one of the main areas of concern in any global movement is the tax effects of relocation. Presumably this is just as relevant for a temporary move. Kirstine?
Yes, absolutely, it will be just as relevant. And as you will have known from your experience, the financial repercussions of an employee working abroad can be substantial, particularly as the employee might acquire tax residency in another country in addition to their home country. As an employment lawyer, I've spent more time on this particular issue recently than I ever dreamed I would. And the one thing that I would really underline is the absolutely critical need to get proper tax advice from a local specialist who really understands the implications of international employment arrangements. It's really important to know what your continuing obligations are as an employer in relation to any tax collection or reporting in the home country of the employee, which may carry on while they're still working abroad. But you also need to understand whether the employee's stay in the host country creates any particular income tax or social security liability in that country. Now, depending on the rules of the particular jurisdiction, that may well be an issue just for the employee to deal with personally. But it could, and this is where it's important to get advice, it could also make you as the employer responsible for ensuring that any local tax or any local social security payments are being calculated, deducted, and reported correctly.
What sort of things will impact the tax position, and anything in particular that employers should be on the lookout for?
Yes, each jurisdiction is obviously going to differ. And again, advice definitely should be taken from an expert in tax rather than an employment expert like myself. But in broad terms, the sort of things you want to be considering are: where is the individual employee domiciled and tax resident? Whether they're going to be doing anything more than just incidental duties in the country that they're travelling to, and whether there might be any applicable double tax treaties or other regulations that might give some sort of exemption from paying taxes in a host country. So there's quite often exemptions where, for example, the length of stay is under a certain number of days. Another crucial area to take advice on is whether the mere fact that you've now got somebody working in a different country inadvertently creates a taxable presence or what they call a permanent establishment for the company in that country. If it does, that could have implications not only in terms of any obligations to deduct income tax or social security, but also impact the corporate tax position. So again, each country is probably going to have certain markers that will indicate corporate tax residency or suggest that it's there, such as if the employee is particularly senior and a decision maker. And again, it just underlines the importance of getting that local expert advice.
Okay. So if we are supporting the employee with this, would employers have to arrange tax advice for the employee?
No, it's not a legal obligation to do that. But if, as an employer, you're going to get tax advice for yourself, which might touch on what the employee's position is as well, it would be prudent to at least flag to the employee that they should be getting their own advice too. Some employers might be happy to pass on the advice that they get in respect of the company if it touches on the employee as well. Others might prefer just to make a contribution towards the fees of the employee going and getting some independent advice.
Okay, any tips that you could recommend?
Yes, I'd say if we sort of limit it to two sort of absolute musts, the employer must take expert tax advice. And the employer must also confirm in the terms of any temporary overseas working arrangement that to the extent you're allowed to by applicable law, you want to be pushing liability for any additional income tax or additional social security onto the employee, and see if you can get an indemnity from the employee in that respect as well. You'd also want to clarify that the employer is authorised to make any additional deductions if there's any additional tax to be dealt with, or you might want to have some sort of reimbursement or recoupment provision from the employee, and also whether the employee will or won't be entitled to any sort of tax equalisation payments to account for any changes.
Okay, thanks for that. Earlier on, Emily and I were talking about some of the immigration restrictions and obligations that apply to remote overseas working. Are there any sort of regulatory or similar issues to bear in mind?
Yes, there are, and we could sort of have a whole nother session on this, but just conscious of time, just to cover it very briefly. I say, depending on the sector or industry that you're working in, then yes, there are very likely to be other legal or regulatory requirements and potential restrictions that you need to keep in mind. One of the most crucial things to check will be whether the company and also the individual employee have got all the necessary approvals, whether that's permissions, qualifications, certifications, whatever it might be, to enable the company and the individual to conduct business or carry out their normal duties from that overseas country. And also check whether they're going to be subject to any additional, for example, local codes of conduct, simply by virtue of being in country. To give a couple of obvious examples, some people on the call will be familiar with the financial services passporting regime. Now, for those who aren't familiar with it, essentially that's talking about where a financial services firm is licensed to do a particular type of business in one jurisdiction, it may be able to do business in another country without needing any further authorizations. There's similar considerations that apply to the insurance sector, where certain activities might be permitted in the home country, but very definitely need additional country-specific licenses or approvals to be carried out elsewhere. And it's a really serious issue. There could be serious repercussions, including criminal, for both the employee and the company if business is being conducted in a country where you don't have those appropriate permissions. There could also be, one thing to check, enhanced reporting obligations or similar imposed by the home regulator. So just to give a contextual example, the UK Solicitors Regulatory Authority, which still governs the likes of Emily and I, has advised firms that they must notify clients in advance if fee earners on their client team are going to be working remotely from overseas. And again, just to sort of wrap that bit up, and at the risk of sounding like a very broken record, the key on this will be to take local advice, local employment advice, tax advice, regulatory advice as well, and also to make sure you've consulted the home regulator, and all of this before any overseas assignment starts.
Brilliant, thank you so much, that's so useful. I actually learned a lot there, so thank you.
Yes, that's exactly what I was going to say. A lot of information. Come to an end of this session. It sounds like something that employers really need to think about a lot. Understand why companies would just have decided to put a ban on this kind of arrangement.
Yes, I've got some sympathy with that. It's definitely not straightforward, and it doesn't look like it's an issue that's going to go away anytime soon. If anything, I think we're all going to see an increase in employee requests to work abroad, possibly on a regular basis, particularly as pandemic working seems to be with us for the future. But that's why people like us about it can be done to mitigate risks. Depending on how many requests you as employers expect to see, it's considering developing a short policy, if only to ensure that those situations are being dealt with consistently and fairly. So, for example, are you going to have the blanket ban that Emma just mentioned, or are you going to have a blanket acceptance of all requests, or are you going to deal with them on a case-by-case basis? And as you said at the beginning, Emma, this isn't just about documentation and procedure and process, but it's about getting this right and fitting it in with the overall benefits package so that we can attract and retain talent. So it is worth a bit of investment.
So looking at everything that we've gone through today, are you points that businesses need to look at in relation?
Yeah, I mean, key takeaways from me from today, and I appreciate we've covered a lot of ground. Starting point, think about whether the employee's role can be performed effectively or legally remotely from the country in question. Think about whether you're going to set maximum durations for overseas assignments, which may or may not be tied into the tax implications. Always, always, always take expert local advice on the proposed arrangements, as we said, from immigration to the labour laws, from tax to social security, and either tell or help the employee to go and get their own advice too. And then finally, think very carefully about what, if any, data processing the employee will be doing, whether that can be done lawfully from the country that they work in, and whether there's any additional security measures that you might need to put in place to guard against data breaches. They would be my key takeaways from today.
Okay, have you got anything that you would add to that, Emily?
Yeah, I guess I'm going to bring it back to the documentation point. I just reiterate the importance of getting the arrangements clearly set out, and whether there are any amendments that need to be made to existing documentation. So as we talked about earlier, you're clarifying, whether the employment contract remains subject only to the home law, or if there is going to be another law that applies. Is the employee allowed to work for anyone else or for themselves during that time abroad, or are they going to continue working solely for the existing employer? Who's got responsibility for making sure they've got the right technology, equipment, arrangements in place to allow them to continue to work effectively from abroad and securely, given Kirsten's points. Making sure it's clear the employee is working from overseas at their own risk, and some protection for the employer. So being clear, it's, the employer is not going to take liability for any loss incurred because of something the employee has done, breaching any local laws. And we talked about health quite a bit, so making sure employee complies with all applicable health guidance in that country. I should also just add, and I've seen a note from Annette, we've talked about quite a lot, not everything. There's also the benefits package. Are there any changes you make or that need to be made around pension contributions, or is there anything that else is going to be affected by this move?
Well, I feel like Sal and I have given you a really good grilling, and a lot of questions and expected a lot. I think we've got back such a lot of which, given that the introduction of that was quite a long time ago, there doesn't seem that much light shed on the actual formalities around that, of which so I think that, well, definitely talking for myself and everybody that's been in attendance, no doubt that a lot of real good quality insight from both of you. So I'm very thankful that you joined on this topic, given this insight. For people that have attended, the contact details of everybody who's presented, if you wish to reach out to them on situations that you may need support with. And in addition, the recording of this webinar will be put onto the forum if there's anybody that you do direct to it there. So overall, thank you very much to my other three fellow panelists here for time today.
It's a pleasure. Thanks everyone for dialing in.